Good evening, viewers. Welcome to my legal class. This is Chandrakala. Today, we will discuss about independence of judiciary. What is meant by independence of judiciary? What are the provisions provided in our constitution to ensure independence of judiciary? Let us study one by one. First, look at our constitution. Constitution has not created any sovereign body. Constitution is supreme. People are supreme. Under our constitution, we had legislature, executives, and judiciary. All these three organs are placed side by side with the concept of separation of power. All these three organs acts like checks and balances. That is the reason why laws made by the legislature looked into by the judiciary. The acts of the executives looked into by the judiciary. This is the checks and balances where these three acts in that form, that is checks and balance, takes place. Due to one organ cannot exercise or abuse its power. Ours is parliamentary form of government. Our constitution framers made an effort to keep these organs separate, but due to the overlapping need and combination of power given to these organs, the strict separation of power is not possible in our India. That is the reason why executives derives the power from legislature and they were accountable to the legislature. In our India, only the judiciary is independent. How our judiciary is independent? Why it is essential for the judiciary to be independent? How it is maintained in our constitution? Let's study. What is meant by, first look at what is meant by independent judiciary. Independence of judiciary means other organs should not interfere in the function of judiciary. Other organs means executives and legislature should not interfere in the function of judiciary. That is called independence of judiciary. Why it is essential? Not for other organs but only for judiciary in our country. Why? Because judiciary is the protector, guardian of our constitution. Ours is democratic country. To protect the democracy, it is very essential. Without any fear, favor of the politicians, other organs, the judges should deliver their judgment, should function without any fear. That is the reason why our constitutions provide protection to the judges to uphold the rule of law and maintain the democracy, protect the constitutional values. So, independence of judiciary is very, very essential. It is the basic structure, characteristic feature of our constitution. So that is the reason why in 1983, S.P. Gupta versus Union of India Supreme Court held that judges should not bend before any power, political, economic. It is the duty of the judges to uphold the value, uphold the rule of law. To protect the democracy is the duty of the judges. This is the independence of judiciary. In a later case, in Supreme Court advocates on record and others versus Union of India, Supreme Court held that independence of judiciary is sine qua non of democracy. What this means? What the sine qua non? What does it mean? It is the essential qualification, essential. That is, independence of judiciary is very essential quality to protect the democracy. It is the it is the duty of the judiciary judges to uphold the rule of law, to protect the constitutional values, to protect the democracy. It should be independent. It is one of the essential quality that is called sine qua non. Understand? This is the and so the in various cases Supreme Court held that Parliament cannot alter the basic structure of the constitutions. Independence of judiciary is also one of the basic structure of the constitutions. This is the reason behind it providing independence of judiciary. Let's see what are the provisions provided in our constitutions to ensure independence of judiciary. Look at firstly appointments of judges. How the judges are appointed. The appointment President of India appoints the judges of Supreme Court and High Courts with the consultation of CJI, Chief Justice of India, and subordinate courts. This is from competitive examinations. Judges are selected. What about CJI, the appointment of Chief Justice of India? How the Chief Justice of India is appointed? Chief Justice of India is appointed out of all the senior most judges of Supreme Court. The most senior most judge will be appointed as CJI. This is the practice and precedent continues for longer period of time. But what's happened after Keshavananda Bharati's case in 1973? Government appointed the fourth senior judge as the CJI. This hurts the other three judges and they submitted their resignation to the government. Next, the collegium system comes into picture. Supreme Court by its judgment held that collegium will recommend the names of the judges and the government will appoint those judges as for the Supreme Court and all the high courts of India. What is meant? What is collegium? Collegium is the senior judges of the Supreme Court headed by CJ. The collegium it came into it is the body created in 1992. So, collegium recommends the names of the judges to the government. Government may send it back to the collegium for reconsideration. After reconsidering, it is binding in nature. President should appoint those judges recommended by the collegium as the judges of the Supreme Court and High Courts. Next, the government created a body called the National Judicial Appointment Commission for the appointment of judges. But Supreme Court nullified the constitutional amendment. That is the reason there is no NJAC in our India. Supreme Court held that it violates the constitutional values because uh, because it is independence of judiciary. It violates the independence of judiciary. Too much of interference of executives, it threats the democracy. So the basic structure will be violated. The principle of basic structure of the constitution will be violated. So the constitutional amendment will be nullified by the Supreme Court. Then the appointment of judges takes place by the appointment by president with the consultation of CJI. In Jet's transfer case, Supreme Court held that consultation of CJI means not mere consultation. It is binding in nature. It is active consultation. So, without the consultation of CJI, there is no appointment of judges in India. So, this is the provisions ensured in our constitution to ensure the independence of judiciary in our India. This is one case, appointment of judges. Next, the salary. The salary was fixed, and also the tenure also fixed tenure. Once the judges appointed, they continue their office till they attain the age of 65 years in case of Supreme Court judges and 62 years in case of High Court judges. It is impossible to remove the judges. Like that, their salary, pensions also fixed. Once their salary is fixed by the parliament, it has no power to alter afterwards for their disadvantages. So it ensures the judges to deliver their judgment without any fear or favor. So this is the main reason behind ensuring independence of judiciary, to uphold the rule of law. Rule of law, the principle of rule of law means all are equal before law, no one above the law. So upholding rule of law is the obligation of the Supreme Court. That is why independence of judiciary is ensured in our constitutions by providing security to the judges, tenure security, salary security, and also involvement of executives in the appointment of judges also reduced. Next, removal of judges. We will discuss the removal of judges in the next class. Thank you.